So the first question is, consider the following statements about contempt of courts. So the question is contempt of courts. The constitutional provisions of contempt of court also have a legal backing. Correct or wrong? How? It has a legal backing. Yes, because we have a legal law, that is Contempt of Courts Act of 1971. So first statement is correct. First statement is in all statements. Second, the Attorney General's prior consent is in writing is required for the Supreme Court to initiate criminal contempt of proceedings. Right or wrong? Right or wrong?
Wrong.
It is right. AG's prior consent in writing is required. Now, when we studied Attorney General's constitutional provision, this point was not there. It means it is not a constitutional provision. This provision is mentioned in Court of Contempt of Court Act of 1971. It is mentioned in the Act. So AG's prior consent in writing is required to initiate. Okay? 2 is correct.
Sir,
Yes.
but Supreme Court can also so more to take contempt of court complaint, right? So in that case, we don't need
No.
other information.
No, normal, but AG's prior consent in writing is required for the Supreme Court. For the Supreme Court also. So moto to karega, lekin in writing it is kind of a procedure. So moto is correct, but it is part of the procedure. ठीक है, Act में लिखा, it is part of the procedure. And this thing had come in Hindu article also last year. If you check, if you type, you will find that law. I guess some famous politician thing happened last year. One contempt of court case. Prashant Bhushan or something. Prashant Bhushan, yes, Prashant Bhushan. Okay, third part. Any amendments in the Contempt of Courts Act will impact the inherent constitutional powers of SC and SC to punish anyone. No. See, constitutional contempt of court simply in the article it is only mentioned 127 कि Supreme Court can do. All the procedures are mentioned in Article 1971. But if you do any changes in the Act, that will not take away the powers of the Supreme Court. It can't. Constitution is always above the law. Yes or no? So any amendments in the Act will impact. No, it can't impact. Inherent positions or inherent powers जो Supreme Court का है वो रहेगा. Clear? So third statement is wrong. Third is wrong. There were pre-independence laws of contempt of India in early high courts and in some courts of princely states. Obviously, contempt was always there. In British time also it was there. British time also it was there, contempt. Now also it is there. So answer is only 1, 2 and 4. 1, 2 and 4. Clear? Okay. Next question is, consider the following statements with reference to again contempt of courts. Every case of criminal contempt shall be heard and determined by a bench of not less than 2 judges. Now again, it is an in-depth question. It is correct statement. It is mentioned again where it is mentioned. So you need to know where it is mentioned. It is mentioned in Contempt of Courts Act 1971. It is mentioned. Second question or second statement. The provisions of Contempt of Courts Act does not apply to the contempt of Nyaya Panchayats or village courts. Absolutely correct. So this is an exception. The contempt of courts will not apply to these courts. It means the provisions mentioned in the Contempt of Courts Act 1971 does not apply to these courts. So here the source is this act. So you have to cover this act very intelligently, not all provisions. Important provisions you'll get in internet. These provisions are in-depth provisions which are related to preparation also. Clear? Okay.